The C-SPAN networks bring you long-form public affairs programming from the nation's capital and are a public service of your television provider. C-SPAN, created by cable.
Thank you, Mr. Chairman. Dr. Comey, I want to ask you about the Apple case as well. The facts of the San Bernardino case are obviously pretty compelling in terms of wanting to know what's on that phone, whether there were other parties involved or other plans or targets of attack. And while that application, as you've pointed out, is focused solely on that phone, when I read the motion in support of the application under the All Writs Act, I don't see a limiting principle. And by that I mean that if that argument is accepted by the court in this case, won't it lead district attorneys and other prosecutors around the country to essentially make the same argument in their cases? And some of those may be compelling. I think you pointed to a pregnant woman who was murdered, I think in Arkansas, and the phone may be the only key to who her killer is. But nonetheless, that application may be good in misdemeanor cases involving nonviolent offenses. And so while the result may only affect this phone, the precedent will be there for many others. And I guess what I'd like to ask you is there a limiting principle here? Is there a way through negotiation that we can arrive at cases where it's appropriate to seek this relief and cases where it's not? Do you acknowledge sort of the broader policy implications of a uniform application under the All Writs Act? Now, I realize this may be mooted by the next generation of operating system, which may not allow this kind of relief, but nonetheless, if it is technologically feasible, even with the next generation operating system, for Apple to help with the opening of a phone, it seems to me that the argument you're making in this case will apply to those new operating systems as well. So is there a limiting principle here, and is there any way to resolve this through negotiation? Because at least the initial positions of the parties are, we need access when we have legal warrant, and the other side is saying we can never provide access because if we do here, we'll have to do it everywhere.
Okay. Thank you, Mr. Schiff. And I should say I very much agree with the way you framed it in your opening statement. This case and all cases are very, very important, but there's a broader policy question that is far larger than any individual case that we all have to grapple with. But to the case, first, I think the answer would best come from a technical expert and a good lawyer. I'm neither of those, but I will take a shot at it. I do think that it is potentially, whatever the judge's decision is in California, and I'm sure it'll be appealed no matter how it ends up, will be instructive for other courts. And there may well be other cases that involve the same kind of phone and the same operating system. But what the experts have told me is the combination, here's where I'm going to get well out of my depth, of a 5C and this particular operating system is sufficiently unusual that it's unlikely to be a trailblazer because of technology being the limiting principle. But sure, a decision by a judge, the judge weighing a decision in Brooklyn right now, all of those decisions will guide how other courts handle similar requests. The All Writs Act, as you mentioned, is a tool that I used as a young prosecutor. We've used for hundreds of years so that courts can have their orders given effect, and how judges interpret that in any particular jurisdiction is not binding on others, but will be important. So I think that's fair to say. But I do think the larger question is not going to be answered in the courts and shouldn't be, because it's really about who do we want to be as a country and how do we want to govern ourselves.
Well, let me ask you about that broader policy question from the Bureau's perspective, and that is, can you live with a policy, can law enforcement live with a policy that says only in certain cases, whether they're violent crimes or other very serious cases, terrorism related, that we would allow under the All Writs Act? I mean, Congress could specify to which purposes the All Writs Act or a change to CLIA would apply. Is that something that the law enforcement community, intelligence community, you think, could negotiate with privacy stakeholders and with the technology sector?
I think conversation and negotiation is the key to resolving this. This is the hardest question I've seen in government, and it's going to require negotiation and conversation. But I've been very keen to keep the Bureau out of the policymaking business. I think we have two roles in this context. One is in the cases. We must do a competent investigation following the murder of 14 people in San Bernardino, and we will, and we'll use whatever lawful tools are available to us. But in the larger conversation, I think our role is just to make sure folks understand what are the costs associated with moving to a world of universal strong encryption. There's tons of benefits. I love encryption. I love privacy. And when I hear corporations saying, we're going to take you to a world where no one can look at your stuff, part of me thinks, that's great. I don't want anybody looking at my stuff. But then I step back and say, you know, law enforcement, which I'm part of, really does save people's lives, rescue kids, rescue neighborhoods from terrorists, and we do that a whole lot through court orders that are search warrants, and we do it a whole lot through search warrants of mobile devices. And so if we're going to move to a world where that is not possible anymore, the world will not end, but it'll be a different world than where we are today and where we were in 2014. And so we just have to make sure that the Bureau explains to folks what the costs are so that people don't look at us 5 years from now and say, where were you guys when this happened? This is too important to let us drift. And so my goal is to have the Bureau be a factual input so we have a really robust conversation that's well informed.
Well, thank you, Director. And I know my colleagues will have more questions, so I'm going to defer to them.
Thank you, Mr. Chairman. Mr. Director, thank you for being here. I appreciate the full committee chairman bringing up the current matter with Apple. I have some very strong opinions about that, and there's a question here, but I want to start by thanking you for being diligent in pursuing the court order and staying on top of this. Look, my view of the world, and I realize that as one member of this committee, doesn't necessarily reflect the entire committee, but this is a court order applying to one phone, and Apple is refusing to comply with that order, and frankly, if their failure to comply means that there is additional information out there that has already contributed to other incidents or will in the future contribute to other incidents of terrorism or national security, I think Apple leadership risks having blood on their hands. And I think Tim Cook is going to have a very hard time explaining why he stood in the way of justice on this issue. So I thank you for what you're doing. This is not my iPhone you're trying to look at. This is the iPhone of Syed Farook, who I believe is an individual who gave up every single one of his civil liberties the day he killed 14 Americans and injured 21. And so I thank you for what you're doing on that. I know our chairman asked what might be on that phone, and it led to a bit of supposition about the content of communications. From a factual standpoint, though, what are the files on a typical phone, and what profile might you be able to build of his activity or communications? As a layperson, I would presume phone calls, messages, but what profile do you not have of this murderer that you might otherwise have?
Yeah, the particular challenge we face in this case is the phone was last backed up over 3 weeks before the attack. And so very often, and again, I don't do any of this to pick on a company. I actually find the company's been helpful in a whole lot of ways. They just got to a point where they said, we will not assist you further. And for reasons that I don't doubt they hold honestly. But if the stuff is backed up to the iCloud, Apple cooperates with court orders, and we get backed up photos or backed up all kinds of records about people we can get lawfully with a judge's authorization. And so anything that might have been backed up to the cloud may still be on the phones. That would be photos or texts or notes or GPS information, where this phone traveled. One of our real concerns here is we have 19 minutes. We can't figure out where they were after the attack. We've looked at every gas station camera, every intersection camera. We have the whole route, but we're missing 19 minutes before they were finally killed by law enforcement. The answer to that may be on the device. And
because a phone would typically, you would have some type of GPS or tower signals that you would know approximately where they were?
Sure. They may have all kinds of locator services turned on in connection with the phone. All of us, I mean, these phones are wonderful, right? I love them.
Sure.
And our entire lives, in a way, are on the phone. And that is why people ask good questions about privacy. But it's also why I want people to take a step back and say, so if we got to a world where those places were warrant-proof, what does the world look like where it's warrant-proof in a certain space in American life? And that's the other thing I want people to understand. It's not the Bureau going and opening people's devices. No, no, no. If we want to open your device, we go to a judge, we make a showing of probable cause, the judge issues a specific warrant, tells us what we can take from the warrant and what we can take from the device or the place and how we can do it.
Well, I thank you for that. Obviously, you know the perspective from which I'm coming. And I am sick and tired in this town and across the country of people not siding with law enforcement. And in this case, that includes Apple and it includes Tim Cook. You've got folks up here that I know side with law enforcement. I appreciate what you're doing. I hope you do prevail. We will leave that to the courts to decide. I don't doubt their intentions, and I agree with you. I don't doubt Apple's intentions. I just think they are wrong on this one, that they are erring on the side of privacy and cloaking what is a national security moment in which they could contribute to a safer America, and they're choosing not to. So I appreciate you. Thank you very much.
Thank you, Mr. Jolly.